Okay, so I wanted to continue reading the Carlton Weiss Trustee Handbook, concise Trustee Handbook. And I'm hoping that I'm sharing. I hope everybody can see that. I made it a little bit larger. Let's see if I can make it even larger. Oh yeah, that works great. I'm getting better at this. So this is where I ended the last reading. And this is page 22. Corporations are artificial creations of the state or federal government under physical charter, which means franchise. Ooh, like Chuck E. Cheese and McDonald's have franchises. Interesting. Okay, so issued via state or federal civil law for commercial regulation under Article 1, Section 8. Hey, Section 8, we've heard that before. Clauses 1 and 3. Interesting. Have you ever heard of Section 8 housing? I wonder if this has got something to do with that. I don't know. Okay, so it says, they are not under the literal common law because of the charter. Well, there you go. So then, just 1 second here. You know, the courts, they're not under literal common law because of the charter. For those corporations, I don't know, what would they be called? Superior Court of some all capitalized county? Would it be the Judicial Council of a certain state or all capitalized state? Those are franchises, just like Chuck E. Cheese and McDonald's, franchises. Somebody's making money. I have a feeling it's judges and lawyers. So any legal action against the corporation is legally called an in rem action because it is against the thing or property, also called res, of the corporation under charter. The courts have automatic subject matter jurisdiction because the physical charter is the subject matter. So the franchise of Chuck E. Cheese and McDonald's and the franchise of the courts is the subject matter. Interesting. Okay, so let's see. I just want to go over this part right here. They are not under the literal common law. Why? Because of the charter. Franchise. Any legal action against the corporation is legally called an in rem action because it is against the thing or property. Are you a thing? Are you property? Also called res. Are you res? No. Of the corporation under charter. So, so the DMV is a corporation, right? And do they convert living souls into their quasi contract shadow employee and make them a thing? Do they objectify them and make them an object or property? Do they dub them the knight or the, I'm just saying, you know how the queen would dub them a knight or a sir? Sir Elton John, Sir Paul McCartney. So that would make them a subject of the queen. Yeah, and like the DMV would make you the subject of their thing because they're dubbing you something, a thing. How do you like to feel objectified? You like to feel like an object? That's what they're doing. The courts have automatic subject matter jurisdiction because the physical charter is the subject matter. So the physical charter is also the franchise. because right here, they are not under literal common law because of the charter franchise. The courts have automatic subject matter jurisdiction because the physical charter, the franchise is the subject matter. So I wonder if they're franchising on the people, making you like Ronald McDonald or Chuck E. Cheese. You got to wear that costume, right? Chuck E. Cheese and Ronald McDonald got to wear a costume to represent, right? Just saying. Okay, so under the letter, letter of the law. Oh, under the letter of the constitutional law. Under the letter of the law, interesting. There is no commercial regulation. No commercial regulation. That kind of reminds me of if there is no regulation, there's no violation. Under the letter of the constitutional law, there is no commercial regulation, but HJR, what's it called again? HJ House Joint Resolution 192, along with 15 USC, and that's not the Trojans, by the way, United States Code, brought in a third party for commercial regulation. What? They brought in a third party for commercial regulation? Oh, they're so tricky. For the Social Security public policy. Whoa, that's interesting. So is that how they're like protecting the public, like public health or the public Social Security public policy? So under the letter of the constitutional law, there's no commercial regulation, but HJR 192. Oh, along with 15 USC, brought in a third party for commercial regulation for the Social Security public policy. You know, because there's no money, there's no gold and no silver that we can be using. So remember, equity compels performance. Let's go up to here. Wait, I missed what the law views unincorporated associations. Oh, an unincorporated association. That's what we read in the last number 4 of the Weiss's Concise Trustee Handbook on page 21 and 22, was talking about the unincorporated associations as a danger to the substance of the common law because of their debt credit system. This is because there is no counterbalance to the demands the association puts on the substance of the earth. Wow. Thus, the reason for all the federal and state regulatory agencies. In other words, there is a presumption by implication in the civil law that a charter, a metaphysical, abstract, unreal type, exists because persons are availing themselves, volunteering of the privileges pertaining to HJR 192. Oh. I wonder if you have to be in this unincorporated association in order to get the privileges of the HJR 192 and have your stuff discharged. Maybe that's how they made it. Let me see. It says, therefore, these persons, those are those persons, the straw man, they come under a quasi in rem, you know, it's like quasi means kind of, sort of. In rem, you're kind of, sort of an object, you know. There's a little gnat around here. It's bugging me. Hey, you straw man. Hey, you object. You're kind of, sort of a quasi in rem. You're like a property, sort of, kind of. That's what they're saying. So therefore, these persons come under a quasi in rem jurisdiction of the civil law, you know, that Roman civil law, in order to regulate, control, including compel. We are compelling you to volunteer. Those that are outside the literal common law principles. Let me read that last sentence again so I can get it. I hate that there's a little gnat or fruit fly right around here. Therefore, these persons come under a quasi in rem jurisdiction of the civil law in order to regulate, control, including compel, those that are outside the literal common law principles. Oh, so if you're outside the literal common law principles, are they saying that they want to kind of compel the people to become persons so that they can use these benefits and privileges of the HJR 192? Is that what they're saying right there? I don't know. Let's look down at 134 and see what the notes say. Oh, great. ID at page 9 through 10. I don't know. Okay. Yeah, I have to keep looking. All right, let's go here. The many participants under this system, especially the 14th Amendment citizen from each state, together form an unincorporated federation of state associations operating under interstate commerce as addressed in Article 4, subsection 3, clause 2, and reinforced by the landmark Erie, is that railroad? R? Oh, Erie River? Erie R. Company versus Tompkins decision. This is the basis for the federal and state government's compulsion of persons to its private international law. So what are they saying? The many participants under the system, especially the 14th Amendment citizen from each state, together form an unincorporated federation of state associations operating under interstate commerce as addressed in Article 4.3.2 and reinforced by the landmark Erie R. Company versus Tompkins decision. I guess if you want to learn more, you can go to that landmark Erie R. Company versus Tompkins, and we can look at it down below too. This is the basis for the federal and state government's compulsion of persons to its private international law. Example, the spirit, not the letter, of the common law mixed with public Roman civil law under the law of nations. Wow. Per Article 1, subsection 8, clause 3 and 10. You guys can read those. And article 6, clause 2. You know what? This thing is bugging me. Okay, nowadays, commonly known as codes and statutes. Oh. So the law of nations use codes and statutes, state or federal, to regulate everything as a matter of commerce. Gotta get that thing. It's bugging me. So nowadays, commonly known as codes and statutes, state or federal, to regulate. Oh yeah, they regulate all right. Everything, that's for sure. Well, why don't they regulate chemtrails? Like, how about don't do them anymore? Everything as a matter of commerce. Without getting into the history of religion and speaking purely from an analytical perspective, the Roman civil law as a base model for commerce regulation was developed out of necessity of the church to avoid political scrutiny for its handling of ever-increasing amounts of precious metals. It had become a storehouse for the money and property that people were persuaded to give in exchange for limited liability. Wow. Go directly to heaven instead of hell. Wow. As the people became more educated and saw what was really behind the power of religion in generating wealth, the Roman Church fell under greater and greater criticism. This led to the development of a banking system. Do you think that the Pope is the one, or the Roman Church, that's doing Bitcoin? Are they the ones that started Bitcoin? Because hello, right here. I'm just saying. Okay, so this led to the development of a banking system to handle and control church wealth and take the critical focus away from the church. Oh, so they started the banking system to take away the heat from the church because they're the ones that were, yeah. How much you want to bet? How much you want to bet? The Pope or something. I'm just saying. Started Bitcoin. The Roman Church. The Roman Catholic Church started Bitcoin. I'm just saying. Somebody did. We'll find out, won't we? Okay, so right here. The bank learned from the church about limited liability. Don't you want to go to heaven? You don't want to go to hell, do you? If you could get people to borrow money beyond their ability to pay back, you could get them to keep performing, paying interest in one form of another or another on a debt liability without ever. Oh, I wanted to read these notes. Let me look at these notes. I have to get back to that. 136. This can be better understood from Propeller Genesee Chief versus Fitzhugh, 53 U.S. 443, 451 to 453, 1851, wherein the court said that within the letter of the Constitution, the law contains no regulations of commerce. It merely confers a new jurisdiction on the district courts, and this is its only object and purpose. It is evident that Congress, in passing the law, did not intend to exercise their power to regulate commerce. The statutes do no more than grant jurisdiction over a particular class of cases. Now, the judicial power in cases of admiralty and maritime jurisdiction has never been supposed to extend to contracts made on land and to be executed on land. Okay, I'm going to read that one again because that's good. So the statutes do no more than grant jurisdiction over a particular class of cases. Now, the judicial power in cases of admiralty and maritime jurisdiction has never been supposed to extend to contracts made on land and to be executed on land. Interesting. But if the power of regulating commerce can be made the foundation of jurisdiction in its courts, and a new extended admiralty jurisdiction beyond its heretofore known and admitted limits may be created on water under that authority, the same reason would justify the same exercise of power on land. See also Berlinden versus Bank of Nigeria, 461 U.S. 496, 1983. That was 461 U.S. 496, 1983. That's the year. Roman civil law is also why the IRS continually refers to income taxes as voluntary, although to the ignorant, it appears to be the exact opposite. What? Roman civil law, you know, your civil rights, is also why the IRS continually refers to income taxes as voluntary, although to the ignorant, it appears to be the exact opposite. Like that it's the law, it's mandatory, it's you must pay taxes. USA, the Republic is the house that no one lives in. Page 9. Oh, wow. All right, so I need to reduce this page for a second. I think, let me see. Can I just scroll down to the next page or no? Nope, cannot. Okay, so I have to read. What happened? Am I still sharing? Okay, I think so. Well, hello. Let's reduce it because I need to, you know, go to the next page. I did it. Okay, page 24. So we're gonna make this big again. I'm pretty sure there's shortcuts here, but I don't know them right at this moment. Okay, so page 24, demanding it, the principal, back, thereby loaning out that same credit to more than one individual or company. This meant that the bank was limiting the liability of the borrower, so he was not fully responsible for the debt as long as he continued to perform to paying the interest. This way, real money, gold, became credit, paper money, by loaning to more than one person. Being involved in this sort of commerce was called private commerce. Oh. With the church's control over wealth, this private commerce became standard practice in world trade upon the sea. Private international or admiralty maritime law became known as Roman civil law as it began to figure heavily in the politics of every city and country it touched. Okay. Through international commerce. All right. So by operation of this body of law, particularly in rem element, particularly its in rem element thing and property, all persons subject to its jurisdiction. Oh, persons, by the way. Persons, all caps name, subject to its jurisdiction are not necessarily regarded as fictional vessels per se, but are more so as objects of the state discussed earlier. Oh man, come on. So these objects, do you feel like an object? Like vessels in traditional admiralty practice are vested with a distinct quasi-corporate juridical personality, but unlike vessels, are capable of suing and being sued in personam. Oh. Interesting. In personam. So you can sue in personam. So these objects, like a, driver, they're like vessels in a traditional admiralty practice, are vested with a distinct quasi-corporate. You do have a driver's license. Can I see your driver's license ID? Because it has your picture on it and your name and all that jazz. And you're like a shadow employee. So it's a juridical personality, meaning it's, under the jurisdiction. But unlike vessels, are capable of suing and being sued in personam. So right here it says, all persons subject to its jurisdiction are not necessarily regarded as fictional vessels per se. Did you know that we are vessels? This is my earthen vessel. I am a spirit. I have a soul, and I live in a vessel, a container. It's of earth. When this vessel passes away or perishes, it goes back to the earth or the dirt. I don't want to be burned or nothing like that. So just saying, it goes back to the ground. The worms crawl in, the worms crawl out through your stomach and out your mouth. Gross. Yeah, go back to the earth. So all persons subject to its jurisdiction are not necessarily regarded as fictional vessels per se, but are more so as objects of the state. Discussed earlier, see footnote 24. We're going to have to see footnote 24. These objects, like vessels in traditional admiralty practice, are vested with a distinct quasi-corporate juridical personality. But unlike vessels, are capable of suing and being sued in personam. All right, check this out right here. 14th Amendment citizens of the United States. Whether state or federal chartered corporations or metaphysical chartered corporate colored. There's another color. There's a corporate color. It's not just black, white, red, and yellow. There's no a chartered corporate colored. Public persons, therefore, are akin to public vessels of the United States within the broad meaning of the Public Vessels Act. What? And are regulated accordingly. Whoa. So 14th Amendment citizens. Okay, so my understanding of the 14th Amendment citizen was after Lincoln and the war, Civil War, they were emancipating the slaves at that time. They were going to allow them provisions to become a 14th Amendment citizen. But now they've made, well, now on all the forms, if you want to vote or something, they say, hey, are you a citizen of the United States? So the people check the box. Yeah, I'm a U.S. citizen. I'm a U.S. citizen. Yeah. So that is under the 14th Amendment right there. Boom. So that's an interesting little fishing expedition. So whether state or federal chartered corporations or metaphysical chartered corporate colored public persons, therefore are akin to public vessels of the United States within the broad meaning of the Public Vessels Act and are regulated accordingly. The United States, as with the Roman Church, what? Wow, I can see that. The United States, as with the Roman Church. Are you seriously kidding me? For real? Dude, seriously. That is like some loud music that I don't want to hear. The United States. Oh, right here. You guys, you've got to see this. The United States, as with the Roman Church, is considered in international law as a ship of state. Whoa, is that Public Vessels Act thing? What? So the United States, that's a ship of state. And the Roman Church, that's also a ship. Whoa. The Express Trust. Wait a minute. The Express Trust then, is akin to a private vessel of the United States of America, navigating through the often hostile waters called interstate commerce, which is international commerce via the United States treaties. So when we express the trust, then is akin to a private vessel. Oh, cool. So when we express the trust, hey, this is the trust of my all caps name. This is a trust. It's akin to a private vessel of the United States of America. That's cool. So this is my yacht right over here, navigating through the often hostile waters called interstate commerce, which is international commerce via the United States treaties. Oh, this is a lot. I need a drink. Lemon juice. Yeah, refreshing. Doing business. This is going to be good right here. Yeah, we need to know that. Even though the express trust is technically not, here we go, folks. It's technically not a business trust. Within the established meaning of the term, this in no way prevents or inhibits the trust. Good. From engaging in all manner of business, the trustee is permitted to under declaration, and it need only obtain the franchise of a business license. Really? Wow, if it anticipates doing express business in the above described jurisdiction. Whoa. So then we do have to get a business license. Okay, so doing business as, does that mean it's a business license? Whoa. This is a great paragraph right here. So even though the express trust is technically not a business trust within the established meaning of the term, this in no way prevents or inhibits the trust from engaging in all manner of business the trustee is permitted to under declaration. And it need only obtain, right here, the franchise of a business license if it anticipates doing express business in the above described jurisdiction. Interesting. The trust may operate a business. Oh, it may acquire a business, sell or otherwise dispose of its business, or even contract under the limited liability system and become a taxable entity. Really? Whoa. So you can get the LLC, the limited liability corporation, and become a taxable entity. The choice is yours. The only thing which may bar the trust from conducting a particular kind of business in any certain jurisdiction is the public policy of that jurisdiction, regarding which it has been admitted most states have not passed upon the subject directly. So down here, no state has ever made any attempt to prohibit express trusts, impair the contract rights of persons sui juris. So when you have a contract, when you're under contract, your contract rights of persons sui juris. Cool. However, many states have attempted successfully to prohibit associations. Oh, is that like PMA, private membership association? Oh, yeah. So, however, many states have attempted successfully to prohibit associations, the most notable being the Ohio Attorney General in State versus Ackerman, Supra against CF Ackerman, and 99 other persons who were, oh, wait, who what? Oh, who were transacting business of guarantee and accident insurance in the state under the name of the Guarantee and Accident Lloyd's, New York. The Attorney General alleged that they were doing business without having complied with the laws of the state or receiving proper authority from the state to do business of that kind. The court found that because the defendants were acting under mere association, as opposed to under declaration of trust, they were an association unlawfully exercising a franchise within the state. Acting as a corporation therein without being legally incorporated. The court indirectly affirmed the well understood principle, scarcely in need of restatement, that express trust may engage in any manner of business allowed to individuals as a natural right. Yes, that's wonderful. In fact, to restate this principle over and over again would be ostentatious. So that's really cool. So an express trust may engage in any manner of business allowed to individuals as a natural right. That's cool. But not necessarily those private membership association. Oh, okay. That's good to know. So as public policy is a form of regulation, it should be noted the case of Munn versus Illinois, 94 U.S. 113, 126 in the year 1876, in which the court expounded on the principle of regulation. Because the trust is of private property and its business is private as well, yes, the trust business is not affected with a public interest. Yeah, that's good. You know how, like, for the public health, we want you to do this, this, and that. Well, a trust business is not affected with a public interest. I hope I got you, Fly, because you're bugging me. It does not become affected with a public interest until the trustee participates in behalf of the trust in the unincorporated interstate banking association. Wait a minute. We got to pay attention right here. Listen to this. Listen to this. Listen to this. Because the trust is of private property. Yeah. And its business is private as well. The trust business is not affected with a public interest. It does not become affected with a public interest until the trustee participates in behalf of the trust in the unincorporated interstate banking association, obtains a business license or other franchise, contracts under it, or conducts the private business of the trust in a manner to make it of public consequence and affect the 14th Amendment community at large. So right here, this is saying that you have a trust and it's private property and the business is private as well. And the business is not affected with the public interest. It does not become affected with a public interest until the trustee participates in behalf of the trust in the unincorporated interstate banking association. Does that mean when you have a bank account? It says also, if you obtain a business license or other franchise, contracts under it, or conducts the private business of the trust in a manner to make it of public consequence and affect the 14th Amendment community at large. So your trust is private property and the business is private, and it's not affected the public interest until you participate in the unincorporated interstate banking association. I don't exactly know if that's getting a bank account. Also, if you obtain a business license or other franchise, it's not private. Contracts under it or conducts the private business of the trust in a manner to make it of public consequence and affect the 14th Amendment community at large. Oh, so if you have a trust and then you have a bank account and you have a business license and other franchise, and you contract under it, or you conduct the private business of the trust in a manner to make it of public consequence and affect the 14th Amendment community at large. When, therefore, one devotes his property to a use in which the public has an interest, he, in effect, grants to the public an interest in that use and must submit to be controlled by the public policy. To the extent of the interest he has thus created. He may withdraw his grant by discontinuing the use, but so long as he maintains the use, he must submit to the control. I would imagine that if you had a business and you told your clients it's a public trust, I mean, not public, private, but some of the people that were coming in got you from the internet and they were public, then in that case, you would have to be doing this public policy stuff because you're supposed to be protecting the community at large, the 14th Amendment. It says, but so long as he maintains the use of, public stuff, then he must submit to the control. Wow. Whatever. It has been suggested that whether the trustee designates his title or not, he is in fact acting as trustee. Yeah. Because the substance, not the form, is what controls. However, for security purposes, I would argue that the designation should be applied in all situations regardless. Doing so will avoid any superficial confusion. So I'm trying to see how I can, I guess I have to just do this to get to the name. Oh, I don't think we finished up here. Huh, did I? No, I didn't. Okay. So we're going to have to finish up here, and I'm going to finish this. Regardless of the nature of the business, there is a due notice rule which confers a duty upon the trustee under equity. The rule consists of two parts. The first is that he should that she should sufficiently distinguish and represent the nature of the trust to the party with whom he is doing business. I operate with a trust. If it is of the utmost importance in the forming of business contracts that full disclosure be made on all letterheads, business cards, checks, bills, and order blanks, papers, etc., so as to prevent any claims of lack of disclosure from arising in the future. Oh, that's a good idea. So if you're going to be operating with your trust, you would need to put it on your business cards, your letterhead, your checks. Oh, yeah. bills and order blanks, papers. Okay. Gotcha. But prudence dictates that a trustee must not disclose every fact regarding the trust, its declaration, and its affairs. The first part of the due notice requirement can be sufficiently accomplished by employing the designations irrevocable express trust organization. That's cool. Or here's another one. Express trust organization, or trust organization, or organized under declaration of trust. Beneath or next to the trust's name. Oh. It must not be excessively revealing about the trust. The trustee has a duty to protect the privacy of the trust, but it also must not be misleading. The trustee has a duty to not compromise the integrity of the trust. He is in no way prohibited from exercising the utmost shrewdness. Oh, that's cool. I like shrewdness. The second part is that he should stipulate in plain and certain language in all written contracts and obligations that the trust only is liable for its obligations, and that neither the trustee nor interest holders are to be held in any personal liability in the contract. Oh, that's great. So I wonder if you wanted to buy a car for the trust, because right here it says that in all written contracts and obligations that the trust only is liable for its obligations. And that neither the trustee nor interest holders are to be held in any personal liability in the contract. Oh. Yeah, I think a lot of people do that. He may also wish to cite the provision of the trust which so limits his or her or the interest holder's liability, but this is often unnecessary. Oh. Like all rights reserved, without recourse, without prejudice. And the trustee should always designate his title, either under or immediately next to his name and signature. Okay, that'd be good. Well, I'm stopping here because I'm hearing a lot of outside noise. It's page 25. Okay, great. So this will be a short one. All right, so I read page 25, 24 and 25. All right, we'll pick this up again soon. Good night.